Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Video number 2114. In this video, we are going to discuss whether DNA test, DNA fingerprinting test can be mechanically ordered by the courts or not. You all know, in paternity disputes, mechanically, of course, basing on the petition filed by the parties, the courts will be ordering them to undergo the so-called DNA test. But here, a peculiar case has come. Actually, it's a dowry harassment case where the topic of paternity has come as a question. So, Justice Aniruddha Bose and Vikram Nath, Honorable Supreme Court. In the case of Inayat Ali is from Hyderabad. Ali and another versus State of Telangana and another in criminal appeal number 1569 by 2022 on 15/10/2022. They held that DNA test should not be ordered mechanically. Why? Because they are invasive of the right to privacy. Right. Now, coming to the facts of the case. So, Inayat Ali's brother's wife, she is the victim in this particular case. Inayat Ali is the brother-in-law of the victim. Inayat Ali's brother married the victim. So, that's why, in order to avoid confusion, I am telling all these relations. Right. So, this victim, she filed a case, an FIR under section 498A. You all know what is 498A. Harassment for dowry, for additional dowry or cruelty. Right. 323, causing simple injuries. 354, assaulting, outraging the modesty of woman. 506, intimidation. 509, IPC. Against, she filed an FIR against harassment. Already told you, he is A2 and brother-in-law is A1, that is Inayat Ali. Her complaint is mainly focusing on the dowry harassment and physical violence by her husband and others also, including the so-called brother-in-law. Right. Primarily. Right. So the case was registered, it was investigated, the charge sheet was filed, and the trial is also going on, and several witnesses were examined. Now the important point has come to light. Please hear carefully. On one occasion, the complainant, that means the victim, she filed a petition under section 45 of the Indian Evidence Act, requesting the court to send her blood as well as two daughters' blood for DNA test to verify whether the DNA is matching with that of A1, that is Inayat Ali. You know, 45 of the Indian Evidence Act, what does it say? Please remember, this is filing a petition for expert opinion. Yes, 100% correct. She has filed the opinion to send the blood to the expert. Why? Because she alleged that she was forced to cohabit with Inayat Ali, even by the husband. She was forced. She was put to fear, as a result of which she was subjected to the intercourse by the brother-in-law, as a result of which two children were born. This is a subsequent petition, please remember. So 45 they have filed. Yes, then the court allowed, and the court directed her and the children. Actually, the court directed the children to give the blood samples in a specified hospital in Hyderabad for obtaining the so-called DNA fingerprint report. Court allowed. Now, it was objected to by the so-called Inayat Ali. Actually, they filed a revision petition before the High Court itself, but they filed a revision petition before the High Court, but it was not allowed. It was also dismissed because to sort out the issue, better to go for the DNA test. Right? Now, why? So, High Court held under three sections. Number one, 53, you all know 53 of the Indian Evidence Act. It says previous good character is definitely relevant. 53A, please remember, previous bad character or evidence of previous bad character, evidence of character or previous sexual experience, it is not at all relevant. Why this dismissal? Not at all relevant. 54. Previous bad character not relevant except in reply. You all know this. So 53A, High Court also did not allow. And High Court also stated that, Arey Baba, it is not testimonial compulsion. And definitely, if you do not obey, definitely we will draw an adverse influence. That's all. You have to undergo the so-called DNA test. Not only the children, the so-called appellant also has to give his blood. So, basing on this, now, what High Court said, definitely you have to go for the DNA test. Now, once again, agreed by the order of the High Court, this Inayatullah, he approached the Honorable Supreme Court of India. So, Supreme Court of India perused the FIR and the petition and noted that primarily it is a case of dowry harassment, and later only the husband's brother has been re-involved or his involvement came into light. Paternity is not directly related to this particular case. If at all she wants to prove the paternity, she has to file a civil suit. Not in this case. It should not be mixed. This is what is the opinion of the so-called Honorable Supreme Court of India. So, Ashok Kumar versus Raj Gupta, 2022, clearly stated that DNA test should not be mechanically ordered. It should be sparingly used. So, when the children are not parties to this particular case, who are the parties? The victim as well as Inayatullah and his brother or other family members, not the children. Why should you invade the rights of the children? Did they ask you? No. So it is nothing but in the right to against the privacy. So you should not make them. Suppose if the children are proved to be warrant to Inayatullah, then what about their future? Will the society accept them? So many difficulties will be there. So blood samples of children who are not parties to the proceedings cannot be ordered, because please remember, it will have so many complications in the future family. That too, according to section 112 of the Indian Evidence Act. Please remember, such birth, so you know, birth which is within 265 days or 285 days. So the father is the person deemed to be. So please remember, if the birth is within 280 days, then it is conclusive proof of legitimate birth. So now if you buy this so-called DNA, you are going to prove it to be illegitimate. So please remember, for this purpose, if at all she is interested, she has to file a civil suit. So therefore, DNA test not allowed. So High Court orders of DNA, they are dismissed by the Supreme Court. Very typical case. Please, unless you read the case thoroughly, unless you hear the video once or twice, it is difficult for you to understand. So please read the case law as well as see my video and enrich your legal knowledge. With this, I am concluding. Thank you very much.